So just hello to everybody. If we haven't met before, my name is Stephanie, and I'm an articling student at Russell Alexander Collaborative Family Lawyers. We want to thank you all for joining us today for Family Law Now Live's presentation on spousal support. So I'm just going to start off with a review of the housekeeping and introductions for those of you who are just joining us now, and then I'm going to let you know what's on the agenda for today. So as we are presenting virtually, we do apologize in advance for any technical issues that may come up. Once I pass things over to our presentation hosts, I'll be available behind the scenes for any questions or tech issues. So if you are having any challenges throughout the webinar, please contact us through the Q&A box, or I'll also provide my colleague Daphne's email address, and we can do our best to help resolve the issues. So in this 1-hour presentation, Bill, Margie, and Susanna will be discussing the following topics that are displayed on your screen. There will also be a Q&A portion at the end of the webinar. So if you haven't already, please feel free to submit your questions through that Q&A box, and we'll do our best to get to your questions during the presentation. Just a quick note that we have made the Zoom settings in a way to allow you to remain anonymous to other attendees, which is also why we have disabled the chat function, but you can still send in your questions or comments to the team through that Q&A box. Please also keep in mind the content of this webinar is to provide you with general information and not to be considered as legal advice. We will be providing links to helpful resources mentioned throughout in the event, through the event in a follow-up email, so keep your eye out for that. And for those of you in the legal community, this program has been accredited by the Law Society of Ontario, and it contains 1 hour of professionalism content. So now it's my pleasure to introduce our host for today, Susanna Crichlow, Margie Primero-Pimentel, and Bill Rogers from Russell Alexander Collaborative Family Lawyers. So I'm going to quickly go through their bios for those who are just learning about these, our team members. Susanna is an associate lawyer who is fully trained in collaborative practice. She has over 7 years of family law experience and works hard to achieve favorable outcomes for her clients in their family law cases. Susanna approaches client consultations with compassionate but analytical mindsets, and she aims to provide her clients with the very best representation possible. She's also passionate about supporting local and international charities and humanitarian aid organizations, including World Vision International, ERDO, and the Salvation Army. Margie has been practicing family law since 2007. She is also a collaboratively trained practitioner and an accredited mediator who is passionate about facilitating fair and reasonable settlements for her clients. She also serves as a dispute resolution officer for the Superior Court of Justice in Newmarket and Toronto. Margie approaches law in a holistic manner and believes that as a family law lawyer, she has a unique opportunity to provide emotionally intelligent advice to clients that will assist them in moving forward with their lives to be in a better position with the best interests of her clients and the children at mind. And last but certainly not least, we have Bill Rogers. Bill is a managing associate lawyer at our firm. His courtroom experience includes numerous motions, several full-blown trials, and he also had the privilege of winning a major family law victory at the Ontario Court of Appeal in 2014.
That's triggering me.
It's bringing back some old memories, some PTSD.
Things got ugly.
So when Bill is not practicing law, he does love spending time playing music with his band, Soul Custody. And if you've tuned in before, we already know the issues with the term there, but it was named before the Divorce Act changes.
I'm going to write a letter.
So now that you know,
rename it custody again. That was such a cool word.
So now that you know a little bit more about our team and what we have on the agenda for today, I'm going to pass things over to Bill to get us started with the presentation.
Thank you, Steph. I really appreciate it. I'm so glad that we have Margie and Susanna here to help out with this. Very excellent lawyers both. And I think we're going to start with poll 1. And this is to see who's out there. Law professional, other professional, all that stuff. When we're waiting for that, I just wanted to talk about the Spousal Support Advisory Guidelines. Some people might have heard Rolly Thompson discuss these. He created them along with Professor Carol Rogerson. And if you ever get a chance to hear Rolly talk about the guidelines, it's super interesting, super informative. And there's if you Google um, SAG user guide. You'll see there's really great resources there too. So if you ever get that chance. Do we get the poll in yet? Oh, there we go. Okay, law professional. That's what I was afraid of. We got to keep this accurate now. Otherwise, they'll know. Okay, so the first, there's actually, we're going to jump right to another poll because this is actually an interesting question, and I've got some comments. So if there's a difference in income, is the lesser earning party automatically entitled to spousal support, yes or no? And I'm just going to wait 2 seconds to before I tell the answer to that. I think a lot of people will know. Why are you smiling at me, Margie? Did I say something dumb already? Margie's a DRO, by the way. That is way cool.
Not really.
Yes, it is. Okay, so do we have the, yeah, there you go. That is, yeah, most people got that right. No. And if you look at, if you Google Spousal Support Advisory Guidelines, the revised user guide, which I just mentioned, that's what Rolly Thompson and Cale Rogerson put together, you'll see what they say. And they say, no, the guidelines only deal with the amount and duration after there has been a finding of entitlement. It's wrong to just run the numbers, okay? And that's something that it took me a while to, when I first started practice, I just thought, well, if there's an income disparity, run the numbers, do it. And most of the time it is. Most of the time but just a need-based entitlement, but you actually do have to investigate that. You can't just automatically assume. So that's something to keep in mind. And on that topic of entitlement, I'm going to pass it over to Susanna. And Susanna, give us a little overview of what the types of entitlement are.
Thanks, Bill. Hello, everyone. It's nice that you guys have joined us today for this presentation. Before we talk about the different types of entitlement, we need to turn to the legislation to see what is the purpose of a spousal support award. We look at the Family Law Act and we look at the Divorce Act, and essentially under the Divorce Act, the court needs to look at the conditions and the means and needs and other circumstances surrounding the relationship. So spousal support can be a very complicated issue. It requires an analysis of what happened during the parties' relationship. What kind of functions did you perform during the relationship, or did you not perform? Is there an agreement relating to your support after the relationship ends? The court also wants to recognize any economic disadvantages you suffered or economic advantages the other person suffered or that they were the recipient of, we look at, did you have childcare responsibilities? Are you going to have more childcare responsibilities after the relationship ends? And the law also wants to promote economic sufficiency, right? Self-sufficiency. We don't necessarily want people to be dependent on spousal support forever. The law also looks at relieving any economic hardship that a relationship has caused to one person. When we consider all of those factors, we look at the different types of support. So we know that entitlement must first be established before we look at the guidelines and figure out duration or amount or where you fall within the guidelines. That's the key legal analysis that needs to be performed. And once you've gone through that analysis, then you can figure out, where do I fall in terms of entitlement? Is this a contractual basis because I have some kind of an order or agreement that provides for my support? Do I proceed under the claim of, well, maybe I'm entitled to compensation, or is this a non-compensatory claim? So when we look at compensatory claims, the law attempts to look at your economic loss or disadvantage that you've suffered and the economic advantage that the other person has received. So is it because, you were a secondary earner, or there are children involved and very young children at that, or maybe older children who also have needs? We look at, do you have children who maybe are disabled, and that might hamper your efforts to become self-sufficient because you may not be able to work as long, right? Because they require special care. We look at, did you have to move to support your spouse's career? Did you give up your own career? Did you work in a family business? We also look at non-compensatory claims. So that would be where there is a great need. And Bill touched on this earlier when he talked about income disparity. And that happens a lot at the end of a relationship, right? Because during the relationship, you merge your income and you cover all of your expenses. But when the relationship ends, all of a sudden you have somebody who is a really high earner, or not necessarily as high, but there's a huge disparity in incomes. And it's unfortunate, but it's also true that a lot of times the women are the lower income earners, and so they need a little bit of support to help maintain a standard of living post the relationship. So the law will also look at what your standard of living was like during the relationship, right? Is one person going to be able to continue that high lifestyle and the other person is going to be on or at the poverty line? So we try to balance that out a little bit and provide economic stability under the need category. We want to look at your budget and what your new living accommodations may mean in terms of the income that you have available to you. We want to look at the other person's budget and what they have available. So when you're proceeding under this category, we also want to look at the length of your relationship, because that helps us figure out where you fall under the range. So it's very important when you're making a claim for spousal support that you critically examine the relationship and each factor in the relationship so you can figure out where you fall. Maybe you fall under one category, maybe you fall under two. Where you fall can affect the amount of support you're going to receive and for how long. So, make sure whether you're a lawyer or you're a client going to a lawyer, you critically examine all of the facts so you can best assist your client in terms of where should I claim entitlement.
Thanks, Susanna. And I just wanted to ask you if you've ever run into what I run into sometimes, which is trying to explain to my client why they have to pay spousal. And one of the things I sometimes say, Susanna, tell me if you agree with me on this. You say to them, look, especially if there's kids, you say, do you really want the other parent to live in a trailer? Because that does not look good. That's not good for the kids. You don't want a super unequal standard of living, certainly not at first. Have you ever run into talking to clients about that kind of stuff? That's what I tell them.
Yeah, I usually tell clients, I go further and say that the reason why the government created this legal obligation to begin with is that they don't want a spouse at the end of a marriage or a relationship to have to rely on the public purse, right?
Right.
They rather have spouses take care of that sort of obligation. And I think the key thing here, and with entitlement, which is one of my pet peeves, is like you mentioned earlier, Bill, lawyers just prepare SSAG calculations and, oh, look, there's an income disparity without really trying to provide a basis for entitlement. And in some cases you have to, there is in my opinion, entitlement is a very weak claim that the other person might have. You really have to look at why is there an income disparity, and does that relate to the compensatory, non-compensatory basis for entitlement? So it's really important to really get over that threshold issue first before you go into the numbers.
Yeah, and a big income disparity can also be an indicator that there is a compensatory claim, which would explain why that person is making so much less. And usually it's childcare.
Mhm.
The compensatory case is MOGE, M-O-G-E, and I think the phrase is sacrifices made for domestic considerations. Usually it's childcare. You give up your career. So that was an excellent rundown, Susanna. And I always say to my client, look, you got to pay. You may as well look at it this way. The money's going to help the kids. It'll trickle down, and you're going to be the hero instead of the guy who's not paying. You don't want to be that guy. I say that to my clients. They have to pay anyway. Try to look on the bright side. Thank you for that. Margie, you've been tasked with explaining the definition of spouse in the Family Law Act and the Divorce Act. Over to you.
So in general, entitlement to spousal support is not limited to married people. It's both unmarried common law spouses and married people can make a claim for spousal support. However, only married spouses may apply for spousal support under the Divorce Act, whereas both married or common law spouses may apply for spousal support under the Family Law Act. And when you might have this situation yourselves in the past, Bill or Susanna, where your client asks, or they think they're in a common law relationship, and they go by the maybe tax law definition of spouse, where you to be living together for a year. But under the Family Law Act, a common law spouse is one individuals who are not married to each other and have cohabited continuously for a period of not less than 3 years, or in a relationship of some permanence if they have a child together.
I never understood what some permanence is.
I know.
It's a little bit of permanence. It's not full permanence. I don't even know what that is.
Yeah, whereas
I know there's case law.
Yeah, you'll have to look at the case law on that. But I imagine if there's a child, that is an indication of permanence. And
Some
living
permanence.
together.
I like the idea of zero permanence.
Well, the last thing I want to point out about the definition of spouse is that under the former Divorce Act, the spouse was defined as either two persons who are married to each other. But with the changes of the Divorce Act that came into effect March 1st, 2021, it includes an extension of the meaning of spouse to include former spouse, because I guess the legislatures thought, we all know what spouse means under the Divorce Act, people who are married. So that's it.
Thanks, Margie. That's helpful information. It shows how things have changed so much over the last few decades. Can we bring up the next? Here we go. This is sort of a trick question. If someone is permanently disabled and will never work again, can their spousal support be terminated? Yes or no? Now, it's kind of a trick question. Maybe it's not a trick. I don't know. Is it a trick? I don't know. Anyway, I'm about to deliver myself of some remarks on this topic, but I think I should wait a tiny little bit. I wonder if you're a payer of spousal support, does it make you feel better if you're paying under the Family Law Act rather than the Divorce Act? Oh, I feel so much better now. It's the same amount. I'm going to try that one next. Okay. Do we have? Yeah. Oh, hello. Okay, so we've got competing answers. It is a bit of a trick question. I think the answer is yes, you can. And the reason I say that is because I went back to the original case that established need-based entitlement, which is called Bracklow, B-R-A-C-K-L-O-W. You can't miss it. It's the Supreme Court of Canada, 1999. And it's interesting that Ms. Crichlow, if you read the decision, she continues, I'm quoting here, continues to suffer from bipolar, mood disorder, obsessive compulsive disorder, and fibromyalgia, and is unlikely to ever work again. That's from the Supreme Court. It was sent back to trial, and the trial judge gave her 5 years, and then it stops. So to me, that says even someone who's disabled and will never work again, you can cut them off after a period of time. In this case, it was 5 years. So is that
Can I say
that
something
accurate?
about that, Bill?
You're a DRO. Is that accurate?
Well, I think it's interesting to note that in Crichlow, the recipient, the parties were married, lived together for 4 years prior to marriage and married for 3 years. So there was a total cohabitation period of 7 years.
There you go. So
maybe
it was a
that-
shorter, yeah.
Yeah.
If
so maybe
they'd been
that was a
together
factor.
longer, it probably would have been different. But I think the principle is you still can cut them off.
Yes, that's why we have, as lawyers, have to make that sort of analysis
Right,
and really
exactly.
dig into the facts.
Yeah. Now, that brings us to our next topic, which is kind of related. It's that's the idea of needs and means, or the need and the ability to pay, and these are factors that are live issues in these cases. Susanna, do you have any inspiration on this?
Thanks, Bill. I think, just following up from Crichlow, one thing that the court looked at is whether the need arose from the marriage breakdown, right? Or was it something extraneous that the payor had no control over? So there are many cases where someone would have a need for spousal support, maybe because of disparity in incomes and lower standards of living, or maybe because of childcare or some other issue. But we also have to look at a payor's ability to pay. So when you run a SAG, if all the numbers end up at 0, there is a mistaken assumption that that means there is no entitlement, but actually it doesn't. All it means is there is an inability at the present moment to pay. And there are cases where, the payor might have child support obligations, and we know that child support comes first. So they may not have sufficient funds left over to pay spousal support, but then in the future, things change, right? The child support obligation ends, and this is where getting into the facts, like Margie said, and the analysis to support your claim for spousal support is actually pretty relevant, because then you can come back later on and ask for spousal support because things have changed and there might be still a need. It's also very important when you're drafting court orders that you try to define under what ground that you're entitled to support, because that also impacts things later on when you come back to court, or if you come back to court and maybe you're seeking a review or variation. There are many orders out there with spousal support claims, and you can't look behind an order. You can only look at what an order says, but we don't know on what ground the person was entitled to support. So we just have to make sure that, those little things we pay attention to down the road. When we look at ability to pay, we should also look at income, right? All sources of income. With my clients and opposing parties, I usually say, I don't just want to see your notice of assessment. I want to see your income tax return, because that's going to show me a little bit of a breakdown as to where this income it came from. And we also look at the last 3 years, so we can kind of trace incomes, especially where we have a payor or an intended payor who's maybe trying to hide funds, or maybe does want you to live in a trailer with the kids.
It depends entirely on the quality of the trailer. It's possible to have a really nice trailer, but mostly it's not good.
not good for the recipient and the children.
It's not good for the kids. It's just bad,
Agreed. Yeah.
unless it's a really nice tree.
It still might be bad, right? But I mean, who wants to always live in the trailer?
Yeah. Well, that's a super important point. Thank you, Suzanne. I mean, especially that idea. And I think Rolly Thompson talks about this. Just because the SAG say there's nothing payable because of the incomes, it doesn't mean there's no entitlement. There might be. And like you said, child support has priority. If child support eventually ends, that could free up money for spousal down the
Yeah.
line, especially if there's a compensatory claim. And you do see a lot of these, what they call crossover cases, where when the kids grow up, then spousal support increases and the child support goes down. And that happens quite often. So
Right, but it's also important when you look at defining the entitlement, right? It's also important when you look at, well, what if my spouse repartners or remarries? Can I reduce my support obligations? Well, then we need to consider, well, on what ground was the recipient entitled? Because if there's a compensatory claim, you may not be able to, right? But
that's right. It's like a compensatory claim. It's almost like a debt that you have to pay regardless of how much money the recipient has, correct?
Yeah, but if it was maybe based on need, then maybe the recipient's need isn't as great as it used to be, right? Which is why the analysis is very important.
Yeah. But if you move in with Jeff Bezos, it would be super cool of you to say, look, I don't need the spousal anymore. I'm calling you from outer space right now. You know what I mean?
Not until you have an agreement in writing with Mr. Bezos and everybody ILA, right?
Yeah, good point. Now, okay, the next topic. Thank you, Susanna. That was most enlightening. Really appreciate it. And I can, you can see what a great lawyer Susanna is. She knows her stuff, and Margie too. Margie, these SAGs, would you care to hold forth on that topic? What are they?
There's a lot to cover.
Yeah. Okay, so we're done. Let's forget it.
Okay. Well,
we have a money back guarantee on these webinars, right?
Yeah.
Yeah. Well, as I was mentioning, the Law Society has said that any presentation I'm involved with, whoever's watching it has to subtract a professionalism hour from their total. Right, Susanna?
No comments, Bill.
Yeah.
I was going to say no comment.
Only one? Thanks for your support. Okay, Margie, over to you. Talk a bit about the SAGs.
So the SAGs stand for the Spousal Support Advisory Guidelines. So I just want to highlight that they're advisory guidelines. Although in Ontario, lawyers and judges will all, base their positions and orders on what the SAGs calculations provide. So they're advisory in a sense that there are ranges and you can go, within the range or outside of the range, and there's flexibility in that regard. But they're advisory guidelines and they suggest appropriate ranges of support in a variety of situations for spouses entitled to support. So again, we don't go into the SAGs calculations until we have, entitlement is, proven or accepted. So once that's done, then we look at, well, what are the numbers? What sort of ranges are we looking at? And one of the things that determines whether, there's even spousal support payable, and this goes to need, are what we call floors and ceilings. So the ceiling and the floor define the upper and lower boundaries of the typical cases where formulas can be used. Above the ceiling and below the floor, the formulas alone cannot be used. Individual adjustments are required at that point. For the floor, if a payer has an annual gross income below $20,000, spousal support is not generally payable. There may be exceptional cases below 20,000 where support is sometimes payable. For a payor whose income is between 20 to 30,000, there may be spousal support payable at the low range or below the low range if there's a strong claim to entitlement and there's a strong need of the recipient. For example, the cases that involve long marriages, older and retired spouses, spouses with disabilities, both spouses having disabilities are examples of scenarios where some spousal support is payable where the payer earns between 20,000 to 30,000. So the issues of the floor really go to the payor's ability to pay. Okay, so ceilings are, if a situation where a payor has an annual gross income above $350,000, there's a presumption that the amounts that are produced by the SSAG's formula are appropriate, or that the formula should be automatically applied. There is no presumption, there is no presumption that they should be, they're appropriate or automatically applied. You have to look at, various factors to determine what the support should be. As counsel, you should look at the facts of each case to see where, how much support should be payable. In general, if a payor's income is close to or not that far above 350,000, the amount of spousal support would likely fall in the low to mid range. It will fall within the formulas, what the formulas provide. And generally, if the payor's income is far above this, the $350,000 ceiling, the amount of support ordered will usually fall below the end of the SSAG range, but at times it can fall within the range. But again, you'll have to look at, where the specific facts of your case, if there are children, there's child support payable, the ages of the parties, and that's a good segue into the factors that are taken into account, whether or not there's a ceiling or not. So when we're talking about the SSAGs, the numbers that are produced depend on a number of factors. So the age is a significant factor, as it may affect the ability to become self-supporting. If the recipient is younger, there's a general presumption that the recipient has the ability to, for example, to retrain and to achieve self-sufficiency. If the recipient is older, there's a rule of 65, which Bill will discuss in greater detail later on. But based on the rule of 65, when a relationship has lasted 5 years or longer, and the years of the marriage plus the age of the recipient at the time of the separation equals or exceeds 65, then the SSAGs provide for indefinite support. Another factor is income. If both the payor and recipient's incomes, both of the payor and recipient's incomes are relevant to the calculation of the amount of support. And the starting point for the determination of income under the Spousal Support Advisory Guidelines is the definition of income under the Federal Child Support Guidelines. So under the Federal Child Support Guidelines, the total income figure on line 150 includes income from all sources, which includes employment income, pension income, interest and dividend income, business or professional income, and employment insurance. However, for the purposes of calculating spouse support, it's important to note that social assistance is not income, and social assistance includes Ontario Works or ODSP. And I don't know if we should get into the concept of imputation of income. I know we're going to be talking about incomes later on, but it should be noted that, a lot of us family lawyers have clients who are self-employed, or clients who claim that they earn a certain number, it's the same certain income and have no real reason for not being to earn more. A payor or recipient may be found to be intentionally underemployed, and in that case might be imputed or attributed with an income. And so, the courts may go beyond what the payor or recipient claims as their income in their income tax returns. The other factor that is taken into account is, children. Child support impacts the amount of spouse support. And I often tell my clients, to view the party's net disposable household income as a pie. And the first piece goes to the children to cover table, child support, and Section 7 expenses. And then anything left over will be used to pay spouse support if there is an entitlement to spouse support. And as you alluded to earlier, you and Susanna, Bill, if child support takes up the bulk of the pie and there is entitlement, especially if there's a compensatory entitlement, it might be that the entitlement continues, and when the children are no longer entitled to child support, spouse support will then kick in. But child support will always take priority before spouse support.
Yeah.
And sorry, you're going to say something, Bill?
No, I'm just agreeing with the crossover cases that they sometimes get called. Child support stops, spousal support kicks in. It happens.
Right. And that's why we have to be careful not to, have our clients release their right to spouse support in those sorts of cases, just because the spouse support calculations show 0 to very little spouse support, right? So the last factor is length of the relationship. The longer the relationship or cohabitation, the longer duration of spouse support, and the stronger the recipient's claim might be for support. So for marriages of long duration, which is over 20 years, defined as over 20 years, entitlement spouse support will usually be found if there is a disparity in the parties' incomes. The last thing I wanted to say, if there's any other factors you guys think we should add about the SAGs, but the last thing I'm going to mention is union dues.
Can you talk about conduct?
Oh yes, I could talk about conduct, but I just on union
Adultery.
dues.
If you commit adultery, you still get spousal support.
Yeah.
Whereas in the 1960s,
yeah,
you didn't. It all became no fault in the late 60s. It came from California. Prior to that, adultery mattered. People still think it does, though. People will say, well, she cheated on me. I don't have to pay her. And I'm like, it's not 1965 anymore, my friend.
They bring you a binder full of evidence that their spouse was cheating on them too.
Yeah.
But you and I were talking about this in preparation for this webinar, Bill, that there's Section 33 sub 10 of the Family Law Act.
Yes.
It's really interesting.
Can I talk about that?
Yeah, absolutely.
Margie and I were talking about this, and Margie, being the genius DRO that she is, brought up the fact that yes, there is no penalty. The Divorce Act actually says the court shall not take into consideration any misconduct of a spouse when it comes to spousal support, misconduct being adultery primarily. However, and this is what Margie pointed out, and thank you for this, Section 33 sub 10 of the Family Law Act, I'm sure everyone watching knows this, but I just have to talk about this really quickly. Quote, the obligation to provide support for a spouse exists without regard to the conduct, but this is the amazing part. The court may, in determining the amount of support, have regard to a course of conduct that is so unconscionable as to constitute an obvious and gross repudiation of the relationship. Thanks for pointing that out. And of course, I did a case law search. I only found one case. It's called Bruni and Bruni, 2010. And it said this is a rare situation, but I just have to tell you what mom did in order to have her spousal support reduced to $1 a month. Quote, her parental alienation was evil, shocking conduct, which amounts to a hideous repudiation of the relationship. And to give you an example, what she did, she told the kids that if they phoned their father or talked to him, the kids would go to jail. So that's what you have to do nowadays to get your support cut off. Yeah. And I only found the one case. I don't know if there's other case law, but Thanks for that, Jim.
Well, there was a case where they found, someone brought forward the husband brought forward this claim that spousal support should be reduced because the wife was, had multiple affairs in her little town, even had an affair with his brother, had his brother's child. And even in that situation, the court did not find it. It met the test of repudiation of relationship, because the test is a very high threshold. The conduct must be exceptionally bad, could reasonably expected to destroy the relationship, and the other spouse has to be innocent or virtually blameless, right? And if you're a lawyer who has this claim and you're like, your spouse, your client wants you to provide this to move forward with this claim, you have to be aware that you really have to be extremely confident in your position, and that you can prove it, that you have the evidence to prove that the other party acted in this manner, because there are cost consequences to the party who brings forward this claim if the court later determines that it's a frivolous issue.
So Margie, she had a kid with the guy's brother,
And she had multiple affairs.
and he still had to pay
was-
spousal support.
It did not affect the amount of spousal support. So it's I think
That's
be careful. Yeah, the section 33 doesn't say entitlement, right? It says determining the amount.
yes.
So,
Well, in Bruni,
you know,
they put it down to $1 a month, but if you can have a kid with the guy's brother and multiple affairs and still get support,
it's a high threshold. It's a
Yeah.
high test to meet.
well, it's all part of the no fault system. They don't want to be litigating that kind of stuff because the court would come to a standstill. That's part of it, right?
But
Yeah.
Bill, if you look at Rowley's commentary in the SSAGs, he also critiques a lot of the case law. And he says, look, if you were before a different judge, I think they may have viewed these facts differently. So
Yeah.
a lot of it, to us, like, I agree with you. I think that's a repudiation of that relationship, but
Mhm.
that judge didn't think so.
Yeah, I think that's right. Anyway, I'm not going to judge. That's why I'm not a judge, because I would be too judgmental if I was a judge. Okay, thank you for that awesome rundown. Where are we? Oh,
Union dues, Bill.
what?
Union dues.
Can we not talk about union dues? Margie, do you want to talk about union dues?
Sorry, yeah, my microphone was off. I was going to say, if you could touch upon that when we get down to the issue, like when we talk about income.
Okay, because I want to talk about NDI.
Okay.
Net disposable income. The only thing I want to say about it is it's not always equalized. As Rowley Thompson says in his thing on the user guide that you can find, NDI is a reality check that looks at the income positions after the spousal support's been figured out. There are some scenarios where it tends to be equalized, and Rowley talks about this, where neither spouse has repartnered and there are no new children. They tend to try to equalize NDI. Another scenario where the shared residency, which is 40% or more residency of the kid, they often tend to equalize the NDI. But as Rowley says, sometimes they don't equalize it, and that happens often where there's big income disparity, which is, as we said earlier, an indicator that there might be a compensatory claim, because why is one person making so little? And in a case like that, very often they do not equalize the NDI. They'll give someone 60% or more. So that brings us into, actually, we've already answered poll 4, but we may as well put it up. Everyone's going to know the answer. Social assistance treated as income? Always, sometimes, never. And I think we mentioned it, so everyone's going to know the answer. Just wait a second. And ODSP is part of it. In Alberta, they call it assured income for the severely handicapped. They call it different things in different places. Let's see what the poll results. Okay, so we've got some different ideas here. According to Rowley Thompson, and again, I can't recommend it enough, just Google SAG revised user guide, you'll see it. Never, 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 social assistance is not income, even though according to Rowley, a lot of courts have decided that it is, but he says they're wrong. And if you receive social assistance, it should not be counted as income. And I guess that would be typically the recipient, right? So yeah, that's that. Next topic. Incomes and financial statements. Margie? And or Susanna? I can talk about it too. Who wants
I
to
can
dive
start.
into this?
I
I
can
always
start.
think of a financial statement as the great opportunity to commit perjury because it's a sworn statement. People don't understand that. It's an oath. And if you lie, which lots of people do, God knows, you're actually committing perjury. Now, perjury you can go to jail for. I've never seen anyone be put in jail for lying on a financial statement, but it is perjury. So I always tell the client, you know what? You got to tell the truth. And if you don't, you will pay the consequences because they will discover you're lying at some point. But are there, besides that, are there any other comments that should be made on financial statements when it comes to this?
Yeah.
Yeah, go ahead, Susanna.
Sorry, Margie, do you want to go?
No, go ahead.
Oh, thanks, Margie. With respect to payors, I find that a lot of times they inflate their expenses, right? Because they want to show this is my income and these are my expenses. So FYI, I cannot pay support. But I've found that judges really scrutinize financial statements because, like you said, Bill, it's an offense, right? To lie on a sworn document. There have been cases too where judges in the past have looked at each entry for your expense and they can reduce some of the expenses that you have on there. So they may think that it's too high, it isn't really reflective. I saw a case back in 2004 where a recipient in one case and a payor in another had a cell phone expense, and the judge said, that's a luxury. You don't need that. I mean, today you wouldn't find a judge who would do that, but this is how detailed the analysis can become, right? So you have to make sure, especially for the recipient, that you properly state what your expenses are. They've even been known to take away expenses like contributions as gifts or charities or even alcohol. Things like that have been eliminated.
5,000 a month for alcohol and tobacco.
Well, sometimes you give a client a financial statement and it comes back at you. And as a lawyer, you yourself have to critique it, because if you don't, a judge will, right?
Mm-hmm.
And a lot of times people, they may underestimate expenses or they may overinflate it. So you have to be careful, because when you look at the income and you look at the financial statement, you have to explain, well, how do you pay for all of this, right? If a judge thinks that you're not being truthful on a financial statement and, they can't really assess your income, for example, because you haven't really provided proper disclosure for a court to be able to assess what your income is, then the court can make an adverse inference against you for failure to provide proper financial disclosure, right? So they can also impute income to you. They look at whether or not you are distorting your income, for example, or whether, there are cases where a payor might want to artificially reduce his income after separation to avoid a spousal support obligation. So again, as a lawyer, make sure you properly assess your client's income and give the court a true picture of what that is really like.
Yeah, and I've got a client who it's a male client. He's a little rough around the edges, let's say. Okay, he's a lot rough around the edges. $0 a month for quote hair and beauty. the judge said, sir, I think you should increase that. It was the only time a court has ever ordered someone to increase their beauty budget. It's a reported case. Actually, I'm kidding. It didn't happen. Thank you, Susanna. Let's go to the next poll. I'm learning a lot here from you, Susanna. Thank you. Poll number 5. In calculating spousal support, we use the length of marriage, the length of cohabitation, 2 different things, or the midpoint between the 2. I think everyone, that's a trick question or something. I don't know. Anyway, while we're waiting for that, I'm going to, Margie, do you want to talk about union dues while we wait for the result?
Oh, yes, yes. So when you're calculating income, as Susanna was saying, and you really have to provide really good, clear evidence about your client's income, and that goes with whether you're a payer or recipient. You want to ensure that you properly put in the right income, like source of income, and that you deduct those, union dues, for example, can be deducted, and there's other adjustments to income that can be made. Those adjustments that are available under Section 3, Schedule 3. I'm sorry, Schedule 3 of the child support guidelines. So because you really want to show, the cash flow that's available to the parties, and that I'm talking about both the payer and the recipient. And you might, if you don't, your client, if you're the payer, might end up paying more than they should be paying, or if they're the recipient, be receiving less than they should be receiving. So,
right. It's all about getting that accurate picture of the money available.
Exactly.
Right. Okay, what do we have for the poll results? Okay, so we've got some different opinions here. Basically, the answer to that is it's the length of cohabitation, period. And very often that's longer than the length of marriage. So you always start with when do they move in together? That's the starting point, and that factors into duration usually of spousals. So that's something. It's right on the divorce mate form. Rule of 65. This is the last thing I'm going to talk about. Then we're going to start answering some questions that have been coming in. The rule of 65, as Margie said earlier, if you take the length of the relationship, not just marriage, cohabitation, and you add it to the age of the recipient on the date of separation, if it adds up to 65 or more, then the duration of spousal support is what they call indefinite. Couple of points to make. Indefinite doesn't mean forever. It just means there's no termination date specified in the court order that's going to happen, but you can still cut it off. And the other interesting thing is the rule of 65 is like the SAGs generally. The SAGs are guidelines, but there's a case called Fisher, 2008 Court of Appeal, Fisher versus Fisher, where it says you don't have to use the SAGs, but if you don't, you have to explain why. Same with rule of 65. You don't have to follow it, but if you don't, you have to explain why. So there you go. Hi, Steph. Are we ready to do some questions?
We are, so I'm going to just do some rapid fire here because I do want to be mindful of the time. So one question that came in, for child support purposes, is social assistance income?
Nope. It's not income for any purpose except to spend when you get it. That's about all.
Thanks, Bill. All right, next question. If I'm on social assistance, do I have to pay support?
Margie, you mentioned that if it's, I don't think so, but.
Well, it depends, right? We're getting into the issue of imputation of income, right?
Oh, you could be imputed, yeah.
Yeah, if you're on social assistance and you can be, depending on the facts of your case, because if you're unable to work because of a disability, for example, then the argument becomes, why aren't you on ODSP, for example? Why are you not in receipt of disability? If you're on social assistance, you can work, and so you might be imputed with an income, at least a minimum wage income.
Good point.
The answer to that is yes, in practice.
Yeah.
you will likely have to pay some support if you're the
Thanks.
payor. Yeah.
Thanks,
Thanks,
Margie.
Margie. All right, we have time for one more quick one. Does indefinite support mean I have to pay support until I die?
Maybe, but it doesn't mean that, like I said a minute ago, all indefinite means is that there's no termination date. Doesn't mean there won't be a termination date. And, it's not easy to terminate. It's better to have a termination date, but if you don't, it doesn't mean you have to pay till you die.
Yeah.
Thanks,
It'll
Bill.
be reviewed. It'll be reviewed. It'll be reviewed
reviewed.
upon material changes and circumstances, such as retirement and loss of employment, etc.
Well, thank you so much. I know that was a lot of content. So we will be taking a brief break over the lunch hour and returning at 2 p.m. for a presentation on divorce and income assessments. Thank you everyone who has stayed tuned in this day. So we have a lot of good presentations coming up, and we will see everyone at 2 p.m. Thank you again, Susanna, Margie, and Bill.
Thank you, Stephanie.